The following podcast is taken from a live broadcast on Inspire FM.
Good evening, everyone, and welcome to the Ask Your Lawyer show. My name is Esther Olasahinde from Liberty Law Solicitors, and I'll be your host for tonight. With me, I have Dean Garrett of Liberty Law Solicitors, who will be joining me to discuss the topic of unfair dismissal and bringing a claim to the tribunal. Thank you, Dean, for coming.
Good evening, listeners.
Okay, so this is going to be an open discussion. So if you guys have any questions, any queries, just give us a call. You can give us a call on 01582 481 822 or WhatsApp message on 0779 481 822. We're also live on Facebook, and it will also be on the Facebook page afterwards. So feel free to have a listen after in your own time. Okay, so topic is unfair dismissal. Dean, what exactly is unfair dismissal?
It's the Employment Rights Act 1996 gives employees a right against unfair dismissal.
Okay.
And what that essentially is that providing the employee has 2 years employment, if he believes he has been unfairly dismissed, he's entitled to bring a claim.
Okay.
Now, going into what unfair dismissal means, provided if a employer can show one of the 5 fair reasons for dismissal, reasons for the employee's dismissal, then that's going to become a fair dismissal. Okay. And it's for the employer to show that it's a fair dismissal.
So is the burden of proof on the employee or the employer?
It's on the employer.
Okay. So what are those 5 reasons?
So the 5 reasons are, the first one is capability, or performance. So an example of that would be timekeeping.
Okay.
The second one is misconduct or conduct, and that can be minor, such as behaviour at work, or gross misconduct, which would be somewhere along the lines of theft. Okay. You would then have redundancy, and that's when an employer is looking to downsize its number of employees. And then you have statutory illegality, which is when it becomes illegal for you to remain in employment. A classic example would be if you were a lorry driver and you lost your driving license, then you would not be able to continue in that role. Okay. And then the 5th and final one is known as some other substantial reason. And that's a sort of a catch-all.
Yeah, it's quite vague. So.
It is vague, and it's therefore any other reason for your dismissal that doesn't quite fit under any of the above headings. So an example of that could be, let's say, a clash of personalities in a business. That could be a business strategy, or it's really open to the employer to justify it, why it comes under some other substantial reason.
Okay, just moving back to misconduct, because that's one of the issues we see coming into our firm that we deal with. How does not the burden of proof, but does there have to be does there have to be any sort of doubt that the conduct happened? There does have to be any real belief that the misconduct actually took place?
So unlike wrongful dismissal, which we will come on to, unfair dismissal, a tribunal isn't actually concerned with whether you committed that act of gross misconduct or misconduct. What they're concerned is whether the employer had a genuine belief that the employee committed that act of gross misconduct or misconduct. Okay. So it's all about whether and we'll come on to shortly what is unfair dismissal and the test for it. But so essentially, does the company or employer have a genuine belief, and can that genuine belief be supported by genuine grounds? Okay,
and does evidence have to come into it? I mean, we'll talk about the process.
Yeah, so genuine grounds would be the evidence that gives the suspicion for that genuine belief.
Okay, so I know you made mention about taking into consideration the test. I believe there's case law for that.
Yeah, so the case law goes back to 1978. It's Birchall versus British Home Stores. Okay. And maybe it'd be best if I explain the case and give you a bit of facts. Background, and then we can explain what the test came. Okay. So the employee, Miss Birchall at the time was accused of selling sunglasses for $6.99.
Okay.
Now, these were modern sunglasses and quite desirable, the ones that turn darker in the sun.
Yeah.
And she sold it to a colleague who's known as Miss L in the case. And she sold it for $6.99 as opposed to its correct price, which was much higher. Now, when the company, BHS, looked into it, they alleged that there was collusion between Miss L and Miss Birchall.
So they kind of maybe secretly came together and said, sell it to me for this price behind their back.
Yeah,
Okay.
sell this product for a lower price. And what transpired was Miss Birchall was dismissed.
Okay.
Now, the case looked at the procedure that the company went through, and they found that Miss L was never cross-examined or questioned, and Miss Birchall was never given an opportunity to respond. So the tribunal, from that, deferred the principles, and I'll take you through those principles now.
Okay.
And it's all to do with fairness. And so the first one principle was, is there a genuine belief that the company has? So in this case, British Home Store has to show that there's a genuine belief that they believe that an act of misconduct occurred, i.e. collusion.
Okay.
Secondly, they have to have reasonable grounds to support that act of belief that a misconduct had happened.
Yeah.
And finally, they have to prove, the third one, is that they conducted a fair investigation.
Which
so,
we'll get on to. Yeah.
So, i.e., in this instance, they failed to question or give a right of opportunity to Miss Birchall or Miss L. And that's those are the three prongs to the Birchall test.
Okay.
Now, often you'll hear of the fourth one, and people get it mixed up with Birchall, but it actually came later. And that was, did the company act within a band of reasonable responses?
Okay.
And what I mean by that is, in the decision to dismiss an employee, was that decision to dismiss as a sanction an appropriate sanction? So, to give an example, if I turned up to work 5 minutes late, but consistently I'm on time, you would naturally say, for that one mishap, I shouldn't. The appropriate sanction shouldn't be dismissal. Maybe a warning. So they will look at your work record, look at the significance or the allegations against you, and look at how severe it is, and look to see whether the sanction actually ties in with it.
Okay. So, coming from that, when, let's say, the issue is the employee's conduct, I know there's something called a Polke reduction. I believe that's when there's some sort of, not discount, but a reduction made due to the employee contributing to their dismissal. How does that work out?
Okay. So, let's say, for example, that the company had a genuine belief, and that genuine belief for the misconduct existed, but they failed to follow a fair procedure. Now, if the outcome was to remain the same, whether they followed a fair procedure or not, the end result would be a dismissal. The tribunal is entitled to say, well, you contributed to your own demise. You contributed through your actions. You're not completely not at fault. Yes, we agree that a fair procedure was not followed, but ultimately you would have been dismissed. So the tribunal is entitled to make a reduction, to say that you've contributed to your own ends. Okay. And that deduction can be made up to 100%.
So you win, but you win nothing.
Yes, that can be a situation.
Not a good
or,
situation.
tribunals will determine this, how much you contributed.
Okay. So you mentioned earlier that you have to have 2 years service. Is there any sort of leeway? There's not, is there?
Not for unfair dismissal. If you were 1 week shy of your 2 years employment, or you can look at your notice provisions, and you could say, with my notice, I would have had 2 years. But that's something that we would have to look at if we were to take on a case and assess your time limits. But there's that exception that you can use your notice period towards the 2 years service. And the other exceptions to it is if you suffered a detriment, for example, at work, and that detriment was you were dismissed.
Yeah.
And you were under 2 years, but you could argue it was based on discrimination,
which we'll get onto. Yeah.
Then you could bring a claim for discrimination as opposed to unfair dismissal.
Okay. So we've given some scenarios of, because when we spoke earlier, preparing for the show, I said for me personally, the way I look at unfair dismissal is there's almost like two sides. So either it's more onerous on the employee or more onerous on the employer. So for instance, if there's an employee fights at work, it's understandable that they would be brought in for a disciplinary hearing. Whereas if it's maybe a smaller act or one of the other reasons like capability, and then the employer doesn't follow the right process. So is there an instance where a matter can be automatically unfair? Is that just in particular to the procedure? No,
there are automatic unfair reasons for dismissal.
Okay.
So, and there's a list and a guidance put out for what constitutes automatic unfair reasons. For example, to be dismissed because of maternity, that would be an automatic reason. And another example would be...
Gone blank?
I've gone blank now.
No problem. That's fine. Let's move on.
But there's a list of automatic reasons out there. They're not very common. And you don't often come across it, mainly because employers are now aware, and I haven't really come across too many automatic reasons.
Yeah, okay. I mean, thinking of the cases we get at Liberty Law or in general that we come across, a lot of the time it's someone that's maybe jumping the gun, so they've not actually been dismissed, but they've maybe been had some disciplinary actions, or they've been suspended, and they call up panicking, explaining the whole issue, and they do have more than 2 years, so of course we can assist them on that matter, and they're worried about the procedure, the suspension procedure and the investigation and the disciplinary procedure. What exactly should they be looking out for?
Okay, so each company may have their own set of investigation, disciplinary and grievance procedures. But the standard that every company should adopt, and it's not legislation, but it's a guidance that the tribunals will look at, is called the ACAS Codes of Practice.
Okay.
Now, the ACAS Codes of Practice is freely available to all employers and employees on the internet. And I would encourage that the guide is very short and is worth a read, just to understand the principles. But in essence, ACAS Codes of Practice looks at stage one, which is the investigation. So here they are telling the employer that before you make a decision to discipline, you have to investigate the matter to work out whether the allegations, suspicions, or the grounds we would call for having that suspected belief exist. And they also have to give the employee an opportunity. And often at an investigation, it should be impartial and open. And it's to rule out having to go forward to a disciplinary. Okay, and it's only after a fair and thorough investigation is conducted will you then have a basis of where the company can decide whether it merits going on to a disciplinary. So that's often the first stage. Maybe some practical tips about investigations. Often you'll have employees coming to say, I was given no notice about the investigation. They just told me there and then at work and invited me into a meeting. An employer is entitled to do that. He's entitled to, or she, as the company, is entitled to call you upon immediately. The purpose is, and it's a practical reason, it's an investigation. If they believe evidence might be damaged or any delay may hamper the investigation, they're entitled to have it there and then. Okay. And again, equally at an investigation, you don't have a right to be accompanied. Though often it's in the company's interest to maybe allow that right to happen.
a lot of not moving forward, but I just want to quickly make a point, because a lot of the time we have someone calling in panicking saying, can I have a solicitor with me, or can you come with me? I know for sure that you can have a trade union rep or a colleague, but is it frowned upon to have a solicitor?
It's not frowned upon. The Employment Rights Act 1996 allows for representatives as either a colleague, so a fellow employee, or a trade union rep to attend. There is no legal obligation on an employer, the company, to accept a solicitor to be in attendance. If a company or an employer permits it, then there's no issue to have a solicitor there. But I'd be very surprised, and I've never come across a situation where a company or employer has agreed to allow that to happen.
Okay. And with the suspension process all the way up to maybe the last disciplinary hearing, how long is that time frame? Because sometimes it can be, we've come across cases where it's quite quick, and sometimes you have people that say, I've been suspended for 2 months or 4 months. What is that about? How? Okay,
so the ACAS Code of Practice states that the investigation and disciplinary procedure should be actioned as soon as possible and dealt with as quickly as possible. It shouldn't be allowed to drag on. It should be dealt with efficiently. Often if an employee is suspended, that suspension shouldn't be seen, it's a risky strategy. Suspension should only be held for allegations that merit it. So if we're talking about performance issues, timekeeping, you wouldn't necessarily say turning up to work late justifies a suspension. And suspension should never be to penalise the employee. It should only be there in order to, and a legitimate reason would be to safeguard the employer or company. So if there was allegations of theft and a proper investigation had to take place, then it's right that while that investigation goes on, that the employee remains suspended. But it should certainly never drag on. And that later on could go towards fairness and be used against the employer to say that I was unfairly suspended, harshly, when it was not necessary.
Yeah. And have you seen instances where a solicitor has got involved during this process to say, look, this is unfair, and how has that worked out?
Often we will be instructed to write letters on behalf of the employee as them, to put across the views, let's say if it reached an appeal stage, or to deter them from continuing with an investigation or proceeding to a disciplinary. But certainly if I've had examples where I've had employees suspended without pay, which is a breach of their contract. And certainly I've written to employers in the past to explain that that's not permitted.
Okay. And still on the topic of investigations and disciplinaries, what if an employee comes forward saying, oh, I feel like the investigation process is biased, or at least the people leading? What options do they have with communicating with their employer? So
this all goes to looking at the investigation and disciplinary process. The person who conducts the investigation on behalf of the employer should be separate to the person who does the disciplinary. The reasons for that is that they shouldn't be tarnished or biased by the investigation. Certainly, if the employee had any personal issues or a clash of personalities with one of the line managers conducting disciplinary, the employer company should think about whether to use them because of the past relationship and any perceived bias they may have. If the employee disagrees and they say, look, the same person who done the investigation is now doing the disciplinary and we have a bad history between us, then that is all going to come and become material later on if it went to a tribunal. The tribunal will look at whether the decision ultimately taken by the company was biased, or what we sometimes phrase as a predetermined decision. Often an employee will say, they wanted to remove me. And this all stemmed from my line manager, who I never got on with. And he started these false allegations, and he led it, or was instrumental throughout. And then we would say that investigation wasn't impartial. It had a predetermined decision that the company was always going to reach a dismissal.
Okay. So before we end on unfair dismissal, I just want to make a point for any listeners out there, and please remember this is an open program. It's for you, the listeners. So if you do want to call in, if you have any questions, do call us on 01582 481 822. We're also live on Facebook, or you can send a WhatsApp message on 0779 481 822. So going back to unfair dismissal, I think one thing I always ask employees or clients that come in is, do you think there is an ulterior motive? Because yes, we should focus on the 5 reasons, but a lot of the time you're going through the 5 reasons and then they come out with, oh, my employer or a colleague of mine said this about me, which we kind of say, is there any sort of inclination for discrimination? I know this topic isn't on discrimination and we have touched on this topic before, so that should be on the Facebook page and on the website if you would like to have a listen. But just to make a point out there that discrimination can also be a major part and something lurking in the background.
And certainly as solicitors, it's our jobs to look and do a full assessment of any potential heads of claim. And certainly if an employee feels that there is an ulterior motive, that's something that should be explored and taken into great detail. I think because I know the break is coming up shortly, that I just wouldn't mind answering a little bit about disciplinary hearings and the stages of the appeal.
We have a few minutes, go ahead.
So once we've moved upon the investigation, we would then proceed with the disciplinary hearing.
Okay.
At the disciplinary hearing, again, the company will put the allegations from the investigation and its findings to the employee. The standard practice would be that they are given notice of when the disciplinary is going to happen, who's going to conduct the disciplinary, and to give them ample opportunity to prepare for the hearing. So if there's been evidence gathered, they should be provided that investigation pack. They should also be given, again, the right, this time they have a right for a representative to attend, which we previously just discussed. And at the end of that disciplinary hearing, the company can then look at the representations made by an employee and come to a decision. And it's that decision which will be the focus of whether it's unfair or fair. So did they listen to the employee's representations? Was the meeting, the minutes, a fair representation of what actually took place?
Really important, yeah.
That is, when it comes, listeners, one piece of advice, when it comes to minutes, do take your time to read after a meeting, the minutes. Often employees will feel under pressure to sign immediately. But don't. I often say, take 5-10 minutes, ask the employer, can I have 10 minutes to go through this in my own time? Or can you email me the minutes? And can I read it in my own time and I will sign it and send back to you? If there's anything in the minutes that you disagree with, you don't cross it out. You just mark it and you put how you believe.
Amendments,
it came across in the meeting, your amendments. And that will become material if you believe there is perceived bias and that the note taker hasn't reflected exactly what has happened in the meeting. And that's a real important tip there if you're going through this process. So an employer, I forgot where I was, but the employer will list its reasons and looking at the evidence. And they will also consider the employee's track record. And this is where we've linked it back to was the decision ultimately, the final decision of dismissal, was that within the band of a reasonable response? So was that the reasonable outcome to come to? If the employee is unhappy with that, they have the right to appeal. And that's part of the ACAS Code's practice. Now,
they can appeal the
decision.
Disciplinary decision.
Yes.
Is that in regards to dismissal or prior?
They can appeal the decision irregardless of whether it's a dismissal or any other reason. So if it's a final written warning, they have the right to appeal that, to say, I believe that sanction is too harsh. But if it was dismissal, they have the right to appeal against the decision. Often what I will see, and this is another tip, practical tip here, is we will often get clients contact us and we'll ask them what stage they're at. And they'll say, we're still at the appeal stage. And the company is dragging their feet. The employer, it's been almost 2 months. And when I hear that, I I panic for the for the new client who's contacted me, because your time limit doesn't run from when the appeal has been exhausted. It runs from the effective date of termination. So when you receive that confirmation from the disciplinary that you have been dismissed, that is your time limit. If your employer has taken more than 3 months to get around to doing the appeal, you're out of time. And listeners, you do need to be careful, because companies are aware of time limits. And I think this is something that we may have to come back to.
Yeah, no, we are running out of time. We're going to go on a break. But I would like to add to that. I'm so thankful you said that, Dean, because not all employers are sneaky. Some may be prepared and some aren't prepared. But you need to remember that if you are going through the investigation procedure and disciplinary procedure, it is your procedure. So you have the right to speak up. You have the right to say, can it be extended? Obviously within reason and for reasonable grounds. But don't be afraid. I understand it's daunting to speak up and ask for assistance or ask for for it to be deterred for another day. So we have touched on unfair dismissal for this first half. Please do join us back for the second half, where we'll discuss more on the tribunal process and unfair dismissal on other grounds.
Assalamu alaikum, this is Atif Nawaz. Listen to Inspire FM shows in your time by heading over to inspirefm.org or listen on Apple Podcasts or Spotify.
Good evening, everyone, and welcome back to Inspire FM and the segment of the Ask Your Lawyer show. My name is Esther Olasahinde of Liberty Law Solicitors, and with me I have Dean Garrett of Liberty Law Solicitors. Thank you, Dean, for joining us again for the second part.
Good evening, listeners.
So before the break, let's stop there. Let me actually tell what the topic is if you're just tuning in. We are discussing unfair dismissal and the tribunal process. So this is an open discussion. And this segment is for our listeners. So if you have any questions or queries, you can give us a call on 01582 481 822 or WhatsApp message us on 0779 481 822. And we will try our best to assist you with the matter. So before the break, we had quite an extensive talk on unfair dismissal. We talked about what it takes to have, what the elements are for dismissal to be unfair. And we also discussed on the disciplinary and investigation process. So moving forward, we're going to discuss a claim that is, I wouldn't say, would you say it's under the unfair dismissal umbrella, or is it separate? This is constructive unfair dismissal.
It falls under the same sort of umbrella, but the test is completely different. So would you like me to explain?
Yes, please.
So constructive unfair dismissal is when you resign from your employment. And unlike unfair dismissal, where we discussed whether the reason for your dismissal was fair or not, the burden is on the employer. Here, the burden is on you. And constructive unfair dismissal claims are notoriously one of the hardest claims to bring at the tribunal. I think a few years ago, they had a 3% chance of success.
3?
Somewhere around that low figure.
Before you move on, why do you think that is the case?
Well, if I tell you the test, and we can run through some scenarios, and then you can tell me, we can agree why. So here you're showing that there has been a fundamental breach of contract, that the manner in which the employer has treated you has been so severe that it's gone to the heart of your contract and left you with no recourse but to end that agreement, to essentially go, okay, I accept your breaches of contract that you've done against me, and you've left me with no recourse but to rip up the contract and walk away. I hereby have no other course but to resign. So to show an action of an employer acting in such a regard that goes to the heart of your contract is quite a difficult thing to prove, especially if the burden's on you to demonstrate, because all the evidence is on you to show. So I've given a really short overview there, but there is often people think there has to be one big act leading to it. But that's not strictly true either. We sometimes call that as the final straw act, that the bit I'm going to talk about. So let's say, for example, I'm working and there's been a series of breaches. So the way comments my employer makes are inappropriate, the way I'm bullied in front of others, or there's a harassment, or I'm placed with overburdened with work, and I'm singled out from the others. I can say, I was prepared to live with being overworked. I was prepared to live with, at the time, being shouted at in front of others. But it's when you add all those breaches, it eventually leads to a final straw where you say, I've had enough. Enough is enough, and that's it. And often you'll see that a unfair dismissal claim will cite the reference implied terms of trust and confidence.
Okay.
Now, on a contract of employment, if you look for it, you won't see the implied terms of trust and confidence. It's built into the contract that an employer will treat you with mutual respect, and equally you treat the employer with mutual respect. So it's an employer-employee relationship. And often if we say that a conduct of employer was so bad, it has gone to the heart of the contract, the implied terms of trust and confidence, that you no longer can trust or have confidence in remaining employed. And that is the test. But again, it's quite a high threshold to prove.
Okay. And with constructive unfair dismissal, can it just be one act? So maybe...
So before, as I was explaining, it can be many acts that lead to what we call the final straw.
Does there have to be a final straw? Or what if it's just one moment where you're saying this is completely unacceptable, I'm done, and you resign? Is that also acceptable?
That is also acceptable.
Okay. And how quickly...
Providing you show that that act was severe enough.
Okay. Which is, again, why it's difficult to bring. Okay.
I suppose to assist the listeners, what we're looking at here is the burden of proof in employment tribunals is a balance of probabilities. So you're having to convince the tribunal on a balance of probabilities, which is 51%.
So more likely than not. Okay. So how quickly does an employee or an individual have to act when they feel that they've reached the end?
Well, the phrase is often the phrase usually used by solicitors is delay is a killer. Okay. And what I mean by that is if you're aggrieved or you believe a breach constitutes you having to resign, if you decide to wait and see it out and then resign a couple months down the road from that breach, a tribunal is entitled to turn around and say, well, if the breach was so severe, if the actions of your employer were so great, you should have resigned there and then. To delay and to carry on working for 2-3 months shows me that it's not so bad. Now, a tribunal will be aware that the decision to resign is not an easy decision for any employee. Ultimately, giving up your livelihood and going into the unknown, unemployment, is not an easy decision to make. So a tribunal will often look and want to see what actions did you take prior to resigning.
Okay.
Did you set a market down? But either way, to leave it for too long certainly will weaken your case. Okay.
So maybe writing a grievance could also show proof?
Show proof, start looking for other jobs in preparation, and then to cite back that the reason you are resigning is because of that, and you couldn't resign at the time because of the requirement to stay employed.
And what is the limitation period? I believe it's the same.
Yep, so it's from 3 months minus 1 day from the date you have resigned. So 3 months. We always say minus 1 day. It's built into me just out of a precautionary safety that we always ensure the claim is submitted within the 3 months time limit.
Okay. And you have to have the qualifying period, I believe, is 2 years.
Again, yes, 2 years.
And there's no leeway.
So there are similarities in that respect. Same time limit, same length of service is required for both unfair and constructive unfair dismissal. But the test is different.
Okay. Moving on, before the break on the first half, we made a small reference to wrongful dismissal. We'll quickly touch on that just so we get all the dismissal headings kind of out of the way. So what is wrongful dismissal?
wrongful dismissal has nothing to do with unfair dismissal. It's completely different.
Okay.
Whereas unfair dismissal is a statutory right, so that's a right built into law under the Employment Rights Act, whether your dismissal falls within one of the 5 fair reasons and whether it can be supported. Wrongful dismissal, on the other hand, is a contractual claim. So it's a claim to say that you've dismissed me, and as a result of that dismissal, you've breached your contract. Now, a typical example of that would be notice. So if you were to dismiss me without my notice pay, I would have the claim for wrongful dismissal.
Okay.
Because I would be entitled to, under my contract of employment, for my notice pay. So if it's 4 weeks notice pay, I would be entitled to bring a claim for that. So my only benefit here, remedies, and I suppose this is how I can separate it between the real difference between unfair and wrongful, is that wrongful, I'm only entitled to be put into a position as if the contract had been complied with. So if it had been terminated and I'd been provided my, let's say, 4 weeks notice, then I wouldn't have a claim for wrongful dismissal because the employer has done what it is entitled to do under the contract. Whereas unfair dismissal, the remedy for that, if you're successful in proving that you were unfairly dismissed, you're entitled to the same basic award, which is calculated in much the same way as I've spoken about in wrongful dismissal.
Yeah.
But you're also entitled to a compensatory award, and that will be your past losses. So from the losses that you've, from the date you were dismissed up to your tribunal hearing, and includes future losses, so potential future losses going on. You're capped at 52 weeks in all, past and future, so you're entitled to 52 weeks maximum.
Okay.
But you should bear in mind that the moment you're dismissed, you cannot just wait for the tribunal hearing to find in your favour. You remain under duty to mitigate. And this is important. If you don't mitigate your losses by, i.e., finding another job or demonstrating that you're not allowing the claim just to be built up, you are you've made concerted efforts to find employment or job seekers allowance to try and mitigate against your losses. A tribunal is entitled to say, well, you're not entitled to the full compensatory sum because you should have mitigated as much as possible. I suppose while we're on remedies, because we've touched upon ACAS codes of practice, where we spoke about fairness and the minimum standards that an employer should take. If an employer fails to follow ACAS codes of procedure, the ramifications can be quite big. Not only will it'll go towards the tribunal finding that the employee didn't follow a fair process, which goes to the heart of the unfair, a decision being made that the employee was unfairly dismissed. It has a financial penalty that a tribunal is entitled to say, well, since you didn't follow ACAS codes of practice, we're going to add enhance the compensation.
Okay.
And they can enhance it by up to 25% of the total sum. So, for example, if I was awarded £10,000 for my unfair dismissal claim, and the tribunal agreed that there should be an ACAS uplift, we refer to it, I could see up to 25%, so £2,500 added onto that claim, if the tribunal believed that the breach of ACAS was so severe. So that is a further caution why companies should be wary and ensure that a fair process is followed.
Okay. So with wrongful dismissal, is it easy to, how is the success rate? Because I'm guessing it's not really based on evidence, it's just on facts.
On facts.
Whether they were paid or not.
Yeah, it's on facts. Was the employee entitled to this benefit or entitlement under the contract? And was the employer entitled to not pay that benefit or entitlement to the employee? So, for example, if we go back to unfair dismissal, if you were dismissed and following that dismissal you were summarily dismissed, what I mean by that is immediately dismissed, you haven't received your notice pay, and because the company says you committed an act of gross misconduct. A tribunal in this case, and you're under 2 years, your only remedy would be to bring a claim for wrongful dismissal because you only need 1 year's employment.
Okay. different than
yeah.
unfairness
So
perspective.
there's no minimum 2 years requirement with wrongful dismissal. So here a tribunal would be looking at whether the company was entitled to say that the employee's breach of contract was so severe.
Yeah.
So really, the success rate is much more,
Higher, I guess.
higher.
Yeah.
It really comes down to the circumstances and the nature of the breach of the contract.
Okay. So moving on, we're going to now discuss the procedure in bringing a claim to the tribunal. So before the break, we discussed about the stages for an investigation, suspension, then an investigation, meeting, and then the disciplinary procedure. So let's now say, Dean, that person had now been dismissed from their job, their employment. Do they always have a right to appeal?
They should always have a right to appeal.
If they're more than 2 years?
If they're more than 2 years, yes.
Okay.
If they're under 2 years, it's still good practice that they have a right to appeal. But essentially, there's nothing they can bring to a tribunal on the procedure of fairness. But without an appeal, the process, and there's been plenty of case law to say that being denied the right to appeal is procedurally unfair. And on that basis, you may just be successful on the claim, even if you contributed towards your own dismissal. And that's something that, you should be wary of your right of appeal.
Okay. So let's say this individual has been given the right to appeal. What tips can we give them? How should they go about appealing the matter?
So they really need to look at why the company came to its decision and whether we agree with that decision. And have they actually looked at all the representations made by the employee? Have they considered all the evidence? And if not, why not? And essentially, there is nothing to lose at an appeal stage. You have already been dismissed. So there's a bit more flexibility in what you can say and put in your full account to the employer. And this will have later important ramifications because a company will have to show that it looked at those representations made and in their decision to, for example, not to uphold its decision, to dismiss, that they did consider the representations. So, for example, the employee's work record, the level severity of the allegations, whether the employee accepts or denies the allegations. Did the employee, for example, apologise?
Okay.
All of these are material. And certainly, a company employer will give you usually 5 days to respond. And there isn't a great amount of time. If you don't appeal, there are ramifications again, and that should be explored. You could take the view if earlier we said if an investigation has a perceived bias, and you've lost all faith, trust, and confidence in the company employer, you could say that, well, what's the point in appealing? They're only going to find out the same outcome against me, and I can show the employer has never started, the investigation was biased, the disciplinary was unfair. Then you may have an argument here that there was no point to go to dismiss appeal because of the conduct of the employer. However, a tribunal will want to see that you have explored every stage before you submit a claim. So the failure to appeal can actually have a knock-on effect to your end compensation that you may get. And they may make a reduction against you on the basis that you failed to appeal. So it's a risky strategy not to appeal. Because the employer will often raise at a tribunal that the employee actually denied me an opportunity to look at their grievances, why they believed my dismissal was unfair. And had they appealed, we wouldn't have come to the same outcome.
Okay. I'd like to make a point on an appeal, because a lot of the time you have a client or someone say, oh, I would like you, the solicitors, to draft the appeal and put it on company letterhead. I mean, I can see how you may think that is a good idea because it might, shake the employers up or make them realize that, you're being serious or you're planning to take serious action. That is not plausible for us or a solicitor's firm to do so, because it's an internal process, if I'm correct. It's your grievance and the appeal process is between the employer and the employee. So it would not, I mean, the employer literally has the right to ignore your appeal. Is that correct?
That is correct. And so that's why an appeal should always be drafted from the employee for safety. Often an employee will say, well, but the company won't listen unless you put on, let's say, a solicitor's letterhead. Yeah. But that would come later, because what you don't want is the company employer to turn around and say, we don't know who Liberty Law for solicitors are, for example, or who these solicitors are. Yeah. We have no contract with you. We cannot comment, and we do not accept your correspondence. And therefore your appeal's not heard. That would be a worst outcome. And there are, which I'm sure we'll come on to in a moment, other letters that a solicitor can send that could be beneficial.
Exactly. So with what you've just said, I believe the next process, or what the next stage we think is helpful, is without prejudice conversations. Could you explain to us what a without prejudice letter or conversation is?
Yeah, without prejudice simply means it's privileged communications. So the conversation I'm going to have with you through this letter can only be seen for your eyes only and for my eyes. Now, the purpose of these key words, without prejudice, is that you can have an open and frank conversation. So if when a client has come to us and it's a claim for unfair dismissal, we can write a letter where we can be frank, honest, and put claimants, the clients, the employees' full claims to the company, to the employer, and essentially say, we're going to bring a claim unless you choose to settle the matter. Yeah. And that allows the employer to listen to the claims that we've pleaded out in front of them and to respond with a settlement proposal, because it remains all confidential. Yeah. And it cannot be relied by either party later on if the negotiations break down in court.
Okay. And
there are exceptions to that rule, but we won't go too much into it.
Okay. When starting without prejudice conversation, like Dean said, it will be on company letterhead. I mean, can it come from an employee without having?
Yes, an employee, and often when a dismissal happens, an employer may actually realise that they've done wrong, and they may approach the employee and say, "Can we have a without prejudice conversation?" And that simply means we're going to have a conversation off the record, and it usually translates into, we're looking to give you some form of compensation for your dismissal or termination if you enter into a settlement agreement. And that's quite often, you'll hear these words quite often, without prejudice. It just simply means off the record.
Okay. And what would you advise the amount of times that you can go back and forth? Because, for instance, say an individual sends a without prejudice letter through a solicitor's firm, they get a response which is no, or do that? How many? I mean, how? Well,
essentially, if the employer shows no interest, then you're essentially just wasting resources in sending letters that may not even get a follow-up or a response. If you are looking at, if it's unsuccessful at that point, there's nothing to prevent a without prejudice conversation coming at a later point. And really, you've got to be mindful of your time limits. Yes. So time isn't your luxury. When you're bringing a claim for, an employment claim, you're under this tight, strict time limit of 3 months. So depending on where you sit on that 3 months, you may wish to proceed with the next step. And an employer may actually take you serious at the next step.
Which is ACAS.
ACAS, yes. I think we're running out of time soon, so I'll get a bit of a quick move on what ACAS is.
We'll try.
ACAS early conciliation is a mandatory step that all employees must take before they can bring a claim to the employment tribunal. A conciliation is essentially ACAS will appoint a conciliator who is to act as a mediator, a go-between both sides, both parties. And they will look to see whether an amicable arrangement or settlement can be reached. The time span of what ACAS can last up to is a month. Usually a month. It can last a day, depending on whether, let's say, for example, you start ACAS, but the employer doesn't wish to engage. Then there's no point continuing, and ACAS will conclude, and you'll receive a certificate. But it usually lasts up to the maximum of a month, but it can actually be extended by further 2 weeks if it's felt that both parties could reach a settlement.
Yeah.
But that is the absolute maximum, a month and 2 weeks.
Mm-hmm.
What's important to note during ACAS is you keep speaking about time ticking down.
Mm-hmm.
When ACAS happens, the time limit is essentially put on pause. And the time spent during ACAS, let's say a month and 2 weeks, can actually be added onto your time limit.
Yeah.
Let's say, for example, it only lasts for 1 day, then you're at the absolute minimum, you're entitled to 1 month after you receive your certificate saying that ACAS is completed and no settlement could be reached, 1 additional month, which is an important, to buy you time in order to prepare and get ready for your claim for a tribunal.
Mm-hmm. Exactly. I'd like to boisterous that point because, a lot of times we have people that come to us that are really close to their deadline. They say, they tell us the day they were dismissed or the last day of discrimination or whatever the matter is. And then we quickly, grab our calculator and then we realise that the claim is due next week. And obviously that's a lot of work to do prior. So if you are looking to do this on your own, please do remember that, with what Dean said, ACAS does essentially pause your time limit, and then you'll have a month for conciliation, and then at least a month on top of that to bring a claim to the tribunal.
So it's whatever it's the minimum is a month, but whatever if it's extended by 2 weeks, it's that time span put onto your time limit.
Yeah.
But certainly working out time limits is a very complicated matter, and if you need assistance, please don't hesitate to give us a call.
Exactly. I think that would be my main I would say piece of advice. If you have an employment issue, please do not, if you think you can, then go ahead. We'll never tell someone to not take a claim to the tribunal. But if you are taking a claim and you feel overwhelmed because the tribunal process is long, it is costly, it's time consuming, and it can be quite emotionally draining for both parties. So I would advise you to at least get some advice before taking a matter to the tribunal to actually see the merits of your claim and to see if there's any other way of settling the matter out of tribunal. So we have actually come towards the end of our program. Unfortunately, we didn't get to go on to talk about the tribunal process, but if you do have any questions, you can leave it on the Facebook page and we will try our best to answer your questions. So that's all we have for today. Thank you so much for joining us, and please join us next week on the next segment of Ask Your Lawyer.
Thank you very much.
Thank you for listening to our podcast. Why not tune in to our live stream at inspirefm.org and follow and subscribe to our social media platforms at Inspire FM Luton.